I'm not sure if you were able to talk to Ms. Wagner, and this is some of my error, but Jennifer had asked me to notice the probation violation, which was set for October for today, which I failed to do. That was my fault, not hers. But
for which one?
for Amanda Way,
Okay.
which she's going to tender a plea today to a possession. And so that would be part and parcel of the violation that was set for October. I forget what date.
Okay. Okay. Did we want to take that case first?
If you want, she's in the jail, so that's up to the jail. And
okay, she's in Wexford. Do we know if Wexford knows to make her available?
I have nothing to do with that.
Okay.
Was she scheduled for court this morning?
Yeah, it was.
She was set for Zoom. I thought I saw it on the list. Yeah. Is she not? Are they up on? Yeah.
I don't see them yet, but we can take some other cases.
Okay.
While we're waiting.
Okay.
Do we have Mr. Smith?
Yes, sir. We do. Let me grab him.
On the record, it's Bill versus Michael Smith, case number 255047. The record should reflect Smith is present here in the courtroom today. I'd like to have counsel put your appearances on.
Brian's here, we have to be clear.
Thomas Seager, attorney on behalf of Mr. Smith.
All right, we set this hearing. There was a bench warrant issued for Mr. Smith's prior failures to appear. He was picked up on that bench warrant as part of, I believe, potential underlying charge. And so Mr. Seager, I read I got the police report on that underlying charge. Is this something that we need to set for a competency hearing?
Yes, Your Honor. I did speak to Mr. Smith this morning, and he indicated that he would have no objection to criminal responsibility and competency evaluation. And I have previously spoken to the prosecuting attorney. It's not my belief that they would object to it.
All right, Mr. Ziegler.
I'm not objecting to this time, Your Honor.
Okay. All right. So, Mr. Seager, if you can prepare those orders, the court will sign those once they're presented. We'll get that process rolling. In terms of, as part of the bench warrant, the bond was revoked. Mr. Ziegler, does he take any position on bond pending that evaluation?
Your Honor, it's definitely concerning that Mr. Smith failed to appear for multiple court hearings and committed new criminal offenses while out on bond. I do think that if the court is going to entertain bond for Mr. Smith, that a higher bond than what was initially set would be appropriate. My notes reflect that his bond was set at $50,000 prior to him failing to appear. So I would ask the court to issue a bond in a higher amount.
Mr. Seager.
And Your Honor, there is already a $10,000 cash surety bond that was set through the district court as part and parcel of the report that the court had alluded to. In any event, Your Honor, I would just ask the court to consider a 10% bond in some amount that would allow him to conceivably post. It's my belief that he's going to struggle to post a $10,000 bond. However, it may be able to be resolved in some fashion or form relative to that. But he's hopeful that he could post some bond. It's my understanding that he wants to continue on with the CMH work if he's able to get back to the CMH. But to that end, Your Honor, he has generally always appeared in court with the exception of the last 2 times. He indicated that he was having some mental health problems. He wasn't generally pretty good communication with me. His mother had regularly communicated with me as to what was happening with him. But he has generally always appeared. He does have long-standing ties to the community.
All right. I think there's a couple compelling factors here in terms of bond. Number one, 2 past failures to appear. Number 2, the offense in this case, one of the offenses is an assaultive offense. The most recent alleged or charged offense is also assaultive. Looking at the police report from that, the court has concerns for public safety given Mr. Smith's mental health issues at this time. given his past failures to appear, I have concerns about his cooperation and appearance for a competency evaluation in this case. So given that there's potential for assaultive conduct, given the mental health issues, given his past failures to appear, and the court's concerns regarding cooperation with competency, I think a higher bond is appropriate. The court is going to, again, revoke the prior bond. The court's going to set bond in the amount of $75,000 cash or surety with all the same conditions. And again, we'll proceed with the competency evaluation once the court signs that order, and then the court will set this for a hearing following receipt of that evaluation. Mr. Ziegler, anything else we need to address for the record today?
No, Your Honor.
Mr. Seeger?
No, sir.
The court's going to dismiss the bench warrant. The court's not going to pursue any additional penalties or contempt sanctions for the failures to appear given the circumstances. And that's all for this case.
Thank you.
Thank you.
Ma'am, are you Amanda Way?
Yes.
Okay. 1 second. All right, we'll go on the record in People versus Amanda Way. We have file number 255078, and then also a probation violation file 244958. The record should reflect Ms. Way is present today by video from Wexford County Jail. If I could have counsel put your appearances on file.
Ryan Ziegler, on behalf of the
Good time to see your appearance with on behalf of Ms. Way.
Okay, so Mr. Seeger, I know we talked about the probation violation file. Are there going to be pleas in both files today?
Yes, Your Honor. It's my understanding that Ms. Way is going to tender a plea to 1 count of possession of methamphetamine. Additionally, Your Honor, as a subset of that, because she's currently on probation, there was a hearing that was scheduled in October. But she would admit that she did violate criminal law. In exchange, all of the counts relative to the probation violation would be dismissed.
All right, Mr. Ziegler, is that a correct statement of the plea agreement?
Your Honor, as to the pending criminal file, yes, I don't take any position on the underlying probation violation.
Ms. Wagner, in terms of the probation violation file, do you have any objection to this agreement?
No, Your Honor, she's gonna plead guilty to count 1 of the non-technical and all other counts under technical and non-technical to be dismissed.
Okay. All right, Ms. Way, have you been able to hear everything that we said so far?
Yes.
And is that the agreement that you've discussed with your attorney, Mr. Seeger?
Yes.
Is that how you wanted to proceed today?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Ms. Way, you understand that on your new charge of possession of methamphetamine, that is a charge that carries with it a maximum possible penalty of up to 10 years and or $15,000 fine?
I do.
And that you were on probation for that same charge of possession of methamphetamine, and that by pleading guilty to the probation violation, it's going to subject you in that case to that same maximum possible penalty. Do you understand that?
Yes.
With all of those things in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
So also with regard to your probation violation, even if you plead guilty to the new charge, you would still have the right to have a hearing as to your probation violation. Do you understand that?
Yes.
And that by pleading guilty to the violation, you're going to be giving up that right as well.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave, which means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of that appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty today?
No.
Has anyone promised you anything other than what we've said here on the record?
No.
Is it your own free choice to enter these pleas?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
So in the new case, that indicates that that incident happened back on March 6th of 2025. Is that the correct day?
Yeah.
On that day, were you here in Kalkaska County?
Yes.
And when you were here in Kalkaska County, did you have possession of methamphetamine?
I did.
Did you know that that's what that substance was?
I did.
Did you have any legal right to have any amount of that at that time?
No.
And at that time in March of 2025, were you on probation here in Kalkaska County?
I was, yes.
And were you aware that one of the conditions of your probation was that you were to not possess any controlled substances unless they were prescribed to you?
Yes.
Okay. Mr. Ziegler, are the people satisfied with the factual basis for the plea in both cases?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Ms. Way, the court finds that in both cases, your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of count 1 in file number 255078, and that you did violate your probation as alleged in count 1 in file number 244958. The court will accept your plea as to both charges. We'll set this matter for a sentencing hearing. In the meantime, Ms. Wagner, you'll be doing the PSI, is that correct?
Yes, Your Honor. Are you okay if I just do an update, or just do like a verbal update for her probation violation since I'm already doing a PSI update?
Yes, yep.
Thank you.
So Ms. Way, Ms. Wagner will be in touch with you for that pre-sentence report. You'll have an opportunity to go through that with Mr. Seeger prior to the sentencing hearing, which will be in about 30 days, and you'll be notified of the date and time of that hearing. Mr. Ziegler or Ms. Wagner, anything else we need to address today?
No, Your Honor.
No, Your Honor.
No, sir.
Ms. Way, did you have any questions?
I don't.
Okay, all right, thank you. That's all for today.
Thank you.
If we could have Mr. Comer.
Yes.
You all set?
Yes.
All right, I will stop that door for you. Stop by control room and complete these.
All right, we'll go on the record in People versus Daniel Comer, file number 255070. The record should reflect Mr. Comer's present here in the courtroom today. I'd like to have Comer.
Your Honor, Ryan Ziegler on behalf of the people.
Thomas Singer agreeing with, and on behalf of Mr. Comer.
This is the date and time set for sentencing in this case. Mr. Comer, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, sir.
Mr. Seeger, are there any additions, deletions, or corrections?
No, Your Honor,
Are there any challenges to the scoring of the guidelines?
they're not here.
And Mr. Seeger, just so that you and Mr. Comer are aware, Mr. Comer submitted a written statement that I did have a chance to review prior to the hearing today. I also had, Mr. Ziegler did have a chance to review the victim impact statement that was submitted as well. Mr. Ziegler, do you have any additions, deletions, or corrections?
Just one minor correction, Your Honor, in the description of offense narrative. Just in the last couple lines there, it says, I'd love to talk to her as well. I'm still in love with her. It should be love.
Thank you. Did see that as I read through it. Any other corrections?
No, Your Honor.
Do you have any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
Yes, Your Honor.
Okay. Mr. Comer, if you can have a seat there next to Mr. Seeger, please. And Ms. Crowley, you want to come forward?
Yeah.
Go right to that chair right there. Can you just tell me your first and last name, please?
Okay, probably.
Okay. Can you tell me what it is that you would like to say here today?
Been years battling with trying to keep them away from me and my kids and keeping us safe in jail time. It's not doing it. I'm just asking you to please give him his maximum and give me time to relocate.
Okay. Is there anything else that you wanted to say? Thank you. All right, Mr. Comer, you can come back up to the podium. Mr. Ziegler, anything that you would like to say on behalf of the people for allocution?
Your Honor, Mr. Comer stands before you for a stalking offense. He has 3 prior domestic violence convictions and a financial transaction device crime arising out of his relationship with the victim. And he has had multiple stalking charges dismissed over the last few years, again, all arising out of conduct with the same victim. The victim has maintained a PPO against the defendant since 2021, and yet he still seems to think it's appropriate to contact her, even by mail from the Wexford County Jail. The victim is clearly, as you saw today, Your Honor, very afraid of the defendant, and rightly so. She has insisted that he stop contacting her since 2021, and he continues to do so. He has no regard for the court's orders, no regard for probation conditions, no regard for the fact that Ms. Crowley does not wish to have a relationship with him whatsoever. I agree with the PSI author that probation at this point serves no purpose, and a lengthy jail term is the only meaningful sanction that can be rendered in this case. Given his track record, Your Honor, I doubt that it will have any rehabilitative or deterrent effect on Mr. Comer's actions, but I do think that it will protect the victim, at least for the period of time that he remains incarcerated. And I think that's all we can really do at this point. So given that the guidelines are 0 to 17, Your Honor, I would ask the court to impose 12 months jail with credit for 105 days.
Thank you, Mr. Seeger.
Here, by way of elocution, I can make no excuse for Mr. Comer, and I've represented Mr. Comer over the course of time in this items. In any event, Your Honor, he has expressed a great deal of remorse. I did admonish him and explain to him that there can't be any further contact absent the PPO being extinguished, which at this time it does not appear as though the complaining witness wishes that to happen, so it should be impressed upon him the importance of following the court order, which he indicated he would. He had indicated to me that he had gone through some personal strife, he was struggling with his mental health, he was struggling with some substance abuse problems. And so he reached out to a person that was familiar, which was clearly inappropriate. Your Honor. 1, there was no in existence, and 2, he was better not to have any contact with their But I think in that moment where he was struggling with his own personal problems, he reached out to somebody that he thought, or at least at one point in time, was a meaningful person in his life. And he clearly made a poor decision. But be that as it may, Your Honor, it is probably somewhat different. I'm not sure how the court will see it, but between somebody showing up on your doorstep and having in-person contact with someone as opposed to sending them a letter. And clearly one is maybe a little bit more aggressive than the other, but sending a letter is not appropriate, but I would say that it's probably the lesser of acts that he could have done in terms of violating the PPO, as opposed to appearing on her doorstep or in person. Be that as it may, Your Honor, he recognizes what he did was wrong. He recognizes that he can't have any contact with her. During the course of his incarceration, he's at least attempted to make the best of his time. He's been engaged in some church classes. He's been engaged with AA. So it's hopeful that he'll be able to address some of his underlying problems while he's incarcerated. He does recognize that he can't have any further contact with her. He's just hopeful that the court will give him a sentence that will allow him to rebuild his life once he's released. But to the extent that the court thinks that additional jail time is required, we just ask the court to consider allowing him to get into treatment of some sort. He has sourced that out. It's my understanding that within a week or so, a bed would be available to him to the extent that he's able to get into that program. And he's hopeful that those things would allow him to make better decisions going forward, and would probably be in the interest of the general public if he's able to address those things.
All right, thank you. Mr. Kummer, anything that you wanted to say today?
Yes, sir. I'd like to apologize for my actions. It was a lapse in judgment. When I wrote the letter, I had just found out that my father had cancer, and I am still terrified that my children won't get to know their grandfather. I know I shouldn't have done it. I know that it was a mistake, but I've been trying to correct my actions. Like Mr. Seeger said, I've been going to church, I've been going to AA, I've had regular visits with CMH. I'm trying to put my time to good use while I'm incarcerated. There will be no further lapses in judgment. I just wish things were different and that my children could know their grandfather without having this have happened, but I'm still here today to take full responsibility for my actions. That's all I have, sir. Thank you.
Okay. Mr. Kummer, I did read through the report, so I'm familiar with the circumstances here. Also about kind of the history of what's gone on and your past history as well. In terms of criminal charges, like I said, I did read through your statement that you submitted. I read through Ms. Crowley's statement. I had a chance to hear from her directly this morning, as well as the lawyer. So I take all of those things into consideration. I think, Mr. Seeger did raise some points that, could be mitigating factors in this case. This was not direct contact. It was a letter, so I recognize that I do think that kind of contact makes a difference. And it does sound like you've undertaken some things to try and deal with the issues that you have underlying this kind of conduct. I also think, though, that there's a lot of aggravating factors here, and in a vacuum, that letter might not seem like the most threatening or the worst type of contact to have, but this didn't happen in a vacuum. That letter came after a long series of events. And when you take it in context, it has a much greater effect than if this was just a one-off. The first time you violated the order, there had never been issues between the two of you prior to that, then maybe, yeah, that letter isn't the most threatening thing in the world. But when it's taken in context with the history, it's clear to me that it had a much greater effect on Ms. Crowley than if it was just a single letter all on its own. So I have to recognize that as well as, you know, your failure over time to correct your actions. And my concerns that, as Mr. Ziegler said, regardless of what we do, you're still going to try and contact her when something goes wrong in your life. And you have to learn that that's just not one of the options that you have anymore when you're having a personal issue, something that you're having trouble dealing with. She is not somebody that you can go to anymore. You're gonna have to find other avenues to deal with those things because they're gonna come up again. Everybody has those types of things at one time or another in their life. So while the court, I think, would have the ability to send you to prison for this, I think the mitigating factors call for at least one last chance at local sanction through jail time. But you need to understand that if you're before me or likely any other judge and you're guilty of contacting Miss Crowley again, the penalties are only going to go up. So you're going to have to decide whether you want to contact her or whether you want to spend time in jail or prison, because that's really your next step after this is prison time. I think so for all those reasons, I think incarceration is a reasonable penalty in this case, and I think it's necessary given the circumstances here, for the reasons I've stated, and a penalty at the high end of the guidelines. So the court is going to sentence you to 12 months in the Kalkaska County Jail. You have credit for 105 days served. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. Hopefully, this longer term of incarceration will impress upon you that you cannot have any kind of contact with her in any way going forward. Hopefully, it'll also provide at least a temporary measure of security and safety to the victim so that she can move on with her life as well. You do have the ability to seek an appeal of this sentence. We're going to provide you with an acknowledgement of your appellate rights. Those papers are going to explain to you, Mr. Clemmer, what your rights are in terms of appeal, as well as how to request a lawyer to help you with appeal. And Mr. Seeger, if you can just have Mr. Clemmer acknowledge those, please.
Yeah, the only question was, and I have alluded to it earlier, whether or not the court would allow him to get treatment to the extent that it's available for it.
I think, again, for the reasons I've stated, there's purposes of punishment and deterrence. It's my view that Mr. Clemmer needs to serve that jail time, so I will not allow him to be released early.
Maybe this is Mr. Atchison.
Okay, Mr. Atchison, the podium, please. The record should reflect Mr. Atchison is present here in the courtroom. This is file number 255072. If I could have counsel with your appearance.
Right.
Obviously, you're appearing with him on behalf of Mr. Atchison.
All right, this is the date and time set for sentencing in this matter. Mr. Atchison, did you have a chance to review the pre-sentence report and go through that with Mr. Seeger?
I did. The only thing that I've seen on the report that wasn't accurate was the violation for not completing anger management.
And you're right, I think it's somewhat just in as much as the report alludes to that he did in fact recently complete it, so.
Where was that in the report?
I think it was like on page 3 or 4. I was reading through it all.
Oh, I see. Okay, I got it.
See that I already did the 10-day violation for this charge.
So
right here.
let me just tell you what this says. He, meaning you, has completed outpatient substance abuse treatment and anger management. So this indicates you did complete it.
Okay.
So is that accurate?
Yes, sir.
Okay. All right. Mr. Seeger, are there any other corrections or deletions?
They're not here.
Okay. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do you have any victims in this case that wish to address the court?
No, Your Honor.
Anything on behalf of the people for outrage?
And Your Honor, I would support the recommendations contained in the PSI. I think given the fact that he's already on a term of probation, that any additional probation would be redundant. It also seems like he's made some reasonable strides towards recovery. So I would ask the court to adopt the recommendations.
Mr. Seeger.
Likewise, Your Honor, I would just ask the court to follow the recommendations. I've had an opportunity to speak with Mr. Atchison. I did impress upon him the importance of not A, violating your probation, B, ensuring that you're not consuming alcohol, and then C, definitely not consuming alcohol while having an occupant who is a minor in your vehicle, which he understands. He knows that he made a poor choice on that day. I think he was struggling with his own sobriety. He was making some bad decisions, as the case is in many instances with people who have substance abuse problems. I did have an opportunity to speak with the district court probation officer. It's my understanding that he's doing much better now as opposed to what he was previously doing. The report seems to lay out that he's doing reasonably well. It sounds as though he'll successfully complete his probation through district court. I would agree with the recommendation in the prosecuting attorney as much as additional probation would be somewhat redundant. It does appear as though this is in there that the district court will be resolved to the extent that he later somehow violates the conditions of his probation through district court. I suspect that you're looking at the full there as well. And so I would just ask the court to limit this to court costs and fines as it's recommended. Understands that he not only puts himself in danger, but he puts the child in danger. He puts the community in danger. Operating a vehicle, especially while under the influence. Somewhat ashamed of what has happened. And hopefully going forward, we don't have a similar thing. I did admonish him and also mention to him that if he should pick up another drunk driving somewhere in life, that would certainly be a problem as it would be.
All right, thank you. Mr. Atchison, anything you wanted to say?
It was a bad move that night. I was drinking a little bit that night when I shouldn't have because I'm on probation. I thought I was okay to drive, honestly, to drive into town. I wasn't. PBT came back 0.8. I shouldn't have put my kids in the car. In a nutshell, I shouldn't have been drinking. You know, that's what this all spans from. But I'm doing better. I'm trying to get rights to my other daughter that I'm not seeing. I got a lot under my plate right now. I cuddled my 2 kids this morning for hours before I came up here. Just, you know, expect for the worst, you know, pray for the best. I'm a good man. I'm a good father. I really am. I do believe this. I just made a mistake.
Okay. Well, I did read through the report. I'm familiar with what happened in this incident. There's information in that report about your history and your circumstances as well. And I take all that into consideration along with what you've had to say and what the lawyers have had to say. And, you know, it certainly is concerning. I mean, an argument could be made that you shouldn't drive with any blood alcohol level with children in the car, especially young kids like that. And when they're not properly secured and in, you know, proper seating and restraint, everything that they should have. So I don't even know that it's a question of whether you were over the limit or under the limit.
It's more along the safety of the children.
Exactly. And, you know, as a father, our job is to protect our children. And I think we spend a lot of time trying to avoid needless risks and then to actively create a risk yourself. Sure is something that you didn't want to do. And I hope is something that you'll think about the next time in terms of your role as a father and a protector of your children. So I hope that this is a learning situation for you and that you reflect on it and that you don't do this again, whether there's children in the car or not. There's certain ways that the court can punish wrongful conduct. One of those ways is jail. Served a couple days on this charge. The other way the court can punish wrongful conduct is financial. And so based on what the lawyers have indicated here and what I read in the report, I think that's the kind of sanction that's warranted in this case. And I think there's adequate protections in terms of the fact that you're on probation already in district court and being supervised and being monitored. So for those reasons, I agree with the recommendation here. Fines and costs. is going to sentence you to 3 days in the Kalkaska County Jail. You do have credit for 3 days served. A crime victim's assessment of $75, court costs of $325, a fine of $250, attorney fees of $350, and a $53 state cost. This is a misdemeanor, so there are no written appellate rights. If you did want to appeal the sentence, you would need to file for that appeal within the next 21 days. If you have any questions about that, because there is a time limit on it, Mr. Seeger would be able to advise you on how to do that. Otherwise, after you leave court today, I need you to go over to the clerk's office next door and make arrangements to pay those fines and costs. Mr. Ziegler, anything further we need to address today?
No, Your Honor.
Mr. Seeger,
No, sir.
good luck to you going forward, Mr. Atchison.
Thank you.
Before I make an error again, I'm pretty sure my docket is done with you this morning.
I think so. Yep. So it looks like our next hearing is set for 10 a.m. We'll take a recess until that time. Okay, we're on the record in People versus Jerry Hines, file number 255079. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
Kyle Travis on behalf of Mr. Hines.
Thank you. Mr. Travis, can you tell me the status of this file today?
Yes, Your Honor, we did hold a prelim in district court. Today we'd be asking the court for a 30-day adjournment because out of this incident, Mr. Hines made some reports to law enforcement, and at least the defense feels that the outcome of those investigations may affect basically plea negotiations in this case, and even Mr. Hines's position going forward. So we'd like to see what happens with that investigation. It's an allegation against one of the alleged victims in this case and some acts that they took. So we'd like to at least get a report on that before we ultimately decide how we're going to go forward with the case.
All right, Mr. Ziegler, can you tell me the status from the people's standpoint?
Your Honor, I would agree. We held the preliminary exam. There were some additional questions that were raised by the testimony of the preliminary exam that I think Mr. Travis and I want some time to look into. I don't have any objection to 30 days just to be requested.
Has there been a plea offer in this case?
Actually, no, Your Honor. We've discussed some potential resolutions, but we haven't come to a firm offer yet. I think we're both very interested in the outcome of this other investigation before we can discuss firm offers.
All right, Mr. Travis, are you gonna be needing a copy of the preliminary exam transcript for any of this?
Your Honor, I haven't ordered it yet, but I should probably order it this week because there is a reasonable chance that's the route we end up going.
Okay. All right, I do want to keep things moving, so if you're gonna need that, then go ahead, make that request so that we can get that in the works. I will set this for another status conference in about 30 days. And Mr. Travis and Mr. Ziegler, I'll just ask the two of you, to the extent, Mr. Ziegler, you're willing to offer any type of plea in this case that occur prior to that next hearing date.
Of course, Your Honor.
Okay. Mr. Ziegler, anything further we can address for the people on this?
No, Your Honor.
Mr. Travis?
Nothing further, Your Honor. Thank you.
Mr. Hines, do you have any questions at all?
No, no.
Okay, just make sure that you stay in touch with Mr. Travis so that you're prepared to go forward at that next hearing, okay? All right, thank you. That's all for today on that file. Is Mr. Warner present?
Yeah.
Oh. Mr. Warner, if you can come right up to the podium there, please. On the record in People versus Jake Warner, file number 255058. The record should reflect Mr. Warner's presence here in courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
Kyle Travis on behalf of Mr. Warner.
All right, this is the date and time set for sentencing in this matter. Mr. Warner, did you have a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, sir.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Maybe a clarification.
Okay.
Mr. Ziegler and I were discussing beforehand in the second sheet that is the recommendations, and it lists $200 in restitution. But later in the report, I think under the victim's impact statement, it indicates that there's a $500 deductible. We would be in agreement that the restitution figure should be $500. And it is my understanding that Mr. Warner has that to pay today.
Mr. Ziegler?
That's correct, Your Honor.
Okay. Any other corrections, Mr. Travis?
No, Your Honor.
Any challenges to the scoring of the guidelines in this case?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court?
Yes, Your Honor.
Okay, Mr. Travis, you and your client can be seated. Ma'am, are you Miss Wooden?
Yes, I am.
You can sit if you'd like, or you can remain standing.
Where do you want me?
Just at that table right there.
Okay.
Just if you could, for the record, just state your first and last name, please.
Lana Wooden.
Okay.
Last year, Jacob Rohner approached me about doing odd jobs. He needed work and was trying to get his life together. He was out on bond and looking at prison time for habitual drug charges. He was very convincing that he just needed someone to give him a chance. I did give him a chance, and we helped him with transportation to and from work. We helped him with transportation to and from his mandatory drug tests at the sheriff's office in Bel Air. In December 2024, I hired Mr. Warner to shovel the snow off several of my roofs. I had to leave for a couple hours. It was a really cold, snowy day. So I left my door unlocked just in case he needed to get warm or use the bathroom. My significant other picked him up later to give him a ride home. When he arrived there, Mr. Warner was looking for a glove that he lost inside my home in my bedroom. Mr. Warner was out of his mind, drugged, making no sense. He couldn't even stay awake on the 10-minute ride to his home. When I arrived home, I walked into my home to find the kitchen cupboard doors opened, noticed my cash was missing right off the bat. I then went into my bedroom where most of my valuables were, to find my underwear drawer ransacked, my jewelry all over my bed. My safes were out, excuse me. My safes were out from underneath my bed, and one of them was open. All the rest of my drawers had been ransacked as well. Nightstand was dumped out. There was cash, prescription drugs, 2 rings, and my late grandfather and my father's military service coins, and my family heirlooms coin collection missing. I instantly contacted Mr. Warner and gave him 1 hour to bring back my belongings. He, of course, failed to do so. After the hour, I contacted the police. Mr. Warner made no attempt to return any of my belongings. Mr. Warner admitted to me and my significant other and the police that he had taken things off my property, and over the next couple of days admitted to stealing several things in text and voicemails, which we turned over to the police. We provided these texts to the police, and the police also asked Mr. Warner if he would just return the family stuff. I wouldn't press charges. He never did. Sorry.
It's okay, take your time.
Even after all of us trying to get the stuff back, it disgusts me how selfish he is that he would not return these items. I figured the cash and the prescription meds were gone, as he was pretty whacked out of his mind for over 24 hours on whatever drugs he had stole from me or bought with the items he had stole from me. He was so whacked out at the time, he even broke his mother's wrist during this when she tried to confront him about getting my items back. That was handled by the state police. I sincerely had just hoped that the family things would come back. One of the rings Mr. Warner stole was designed by my late father, and it was a gift for my 16th birthday. Still fit, believe it or not. The cash and the prescription drugs I can live without, but my father and grandfather's coins are another story. Mr. Warner refused. Mr. Warner has refused to even tell us where he sold them to or traded them for his drugs. Some of the coins that have taken have been in my family for over 100 years. My grandfather was a World War I veteran. My father, a Vietnam War veteran. Most of these coins came back with them from overseas, from them fighting for this country. There is no price to replace the sentimental value for myself, my sons, or my grandsons that would have inherited it someday. Mr. Warner was charged with felony larceny as a habitual offender and was offered a plea, which he accepted. The plea was for attempted, which is a misdemeanor, with no consideration for my entire family and our family heirlooms that are gone forever. He continues to get away with these horrible things he does with just a slap on the hand and probation. He thinks that stealing is okay, and that is just so wrong. I no longer believe in helping out people. I don't give them just a chance anymore. I now have security cameras all over my property. If someone is doing work for me outside, they no longer can use my bathroom. They can go down the road and use the stores. I'm not sure I will ever get over the loss of this family stuff. My privacy was invaded knowing that he has gone through my underwear, my bras, etc. These are very private things, and it is very disturbing behavior for somebody to do that. This is just not just heartbreaking for myself, but for my 82-year-old mother, my sons, and my grandchildren. As a victim listed in this crime, I think it is so sad and honestly feel it's a crime itself that even with the evidence and multiple confessions, he gets away with a misdemeanor so he can go do this to someone else, as he has been allowed to do repeatedly. This was not his first time or his second with stealing things or drugs. He continues to hurt whoever he chooses to feed his drug addiction. I know that I can't change that the offer for the plea was for a lesser charge, but I would ask the court to please consider these are not just things that he took. These are items that were meant to be in our family and are a part of our family history. Ask yourself, how many times does he get away to do this to other families? When will he be taught that stealing is wrong? When he is using drugs, he is a danger to others and is proven by breaking his own mother's wrist. When he is wanting drugs, he has shown that he will break the law, lie, steal, be violent, and put the safety of our community at jeopardy. In closing, I want to stress how sad and heartbroken I am over the one ring and my family's coins. This has changed me forever, and I still feel very violated by what Mr. Warner chose to do. I ask you to also consider that my grandfather was a World War I vet, and his military memorabilia is lost to my family forever. I ask that you please sentence him with the most severe sentence that you legally can and the longest jail time or prison time that you can. I also ask the court upon release that besides probation, you put him in a long-term drug program. I think it is the only way that we stand a chance that he will not continue to do this to society. He has learned how to get away with doing drugs and what drugs he can take for 24 to 72 hours that'll be out of his system. I also ask that you give him daily drug tests instead. This is not his first or second offense with drugs and stealing. I'm just his last victim. Please make his punishment stiffer so that no other family has to go through what mine has. Thank you.
Thank you. Anyone else, Mr. Ziegler?
No, you're right.
Anything on behalf of the people for allocation today?
Your Honor, I think what the statement of Ms. Wooden exemplifies in this case is that when people commit these types of larceny offenses, it's not really so much the property itself that's the problem. I think clearly Ms. Wooden has insurance and she can be compensated through insurance. The defendant will be forced to pay restitution. But really what the crime does to victims and to the community is it makes them feel unsafe and untrusting in their own homes. And as Ms. Wooden said, she's now reconsidered whether or not people coming to her house to do work can come into her house. She's much less trusting of these individuals. She feels that her personal space, her personal items have been violated. And that's certainly understanding, and it's heartbreaking. It's the real problem with these types of offenses. It creates a general distrust of other people in the community. Had this case come here in a vacuum on an attempt larceny in a building, which is a 2-year felony, I think what I would be asking the court for is a lengthy term of probation with some jail in advance to make sure that the defendant gets the treatment he needs, follows through with probation, and we have something over his head to ensure that. That's somewhat complicated in this case by the fact that he's already on probation in another case, and he will be on probation for the next 2 years. So I guess what I would ask the court to do is either to consider some upfront jail in this case, send a message to the defendant that this type of behavior has lasting implications, not just for the victim in this case, but for the community at large. Or alternatively, to hold some jail in abeyance and make sure he does follow through on that other term of probation and make sure that he does get the help and the treatment that he needs. Thank you.
Mr. Warner, if you want to come back up to the podium, please. Mr. Travis, anything on behalf of your client?
Thank you, Your Honor. Your Honor, I would note there's at least what I believe to be an update to criminal history attached. I don't see anything relative to an assault or domestic violence indicated in there. Mr. Warner, obviously, you've got the rest of his CCH. There is a pretty long history of substance abuse problems, among other problems. He does come before the court, having done, I think, about 4 months of drug testing and having that going well. He is getting Suboxone treatment. He was indicating to me that his most recent substance abuse assessment from Catholic Human Services indicates that he is in remission with his substance abuse problem, probably largely due to the Suboxone treatment. But he does come before the court, and I think that's part of where probation is making their recommendations. He's actually doing fairly well with the substance abuse problem as he stands before the court today. Obviously, that wasn't happening back when this occurred. Obviously, that wasn't happening when he got a substance abuse charge in Antrim County, to which he's on felony probation for that. I think Mr. Warner has expressed to me numerous times his remorse. As you may note from the report, he doesn't exactly agree with what happened here, but obviously something happened, things are missing, and he admitted to much of this. So, Your Honor, he is doing well. Obviously, we understand, and I think Mr. Warner will express, he's quite remorseful about what he did, and he does feel bad about what he did. But we're here on a theft case, but I think the overreaching issue with Mr. Warner is probably substance abuse, as was indicated that he's allegedly out of his mind here. That's been a consistent reported theme of what his behavior was that day. So, Your Honor, we would ask the court to follow the recommendations. Thank you.
Mr. Warner, anything you wanted to say today?
Yeah, I just want, I'd like to apologize to the courts, and also Glenna for having to go through with this. Back when this happened, she was a friend. I shouldn't steal from friends because as friends help each other out. I just was in a bad way. I was homeless, living in a motel, but I'm just, please let the court see, and give me an opportunity to keep doing what I'm supposed to be.
All right, I did read through the report, so I'm familiar with the factual basis for why you're before the court on this charge today. There's lots of information in there about your background, your prior charges, your circumstances in general. And I take all that into account along with what you've had to say here today, what the lawyers have had to say, Ms. Wooden, certainly what you've had to say. I appreciate your comments. I think you really articulated very effectively what it's like to be the victim of this type of crime. And your feelings came across very clear to me. And it's very apparent to me how this would affect somebody, not only from the standpoint of just a violation of your personal private space, but the loss of things that really don't have a monetary value. I'm sure that you would give up that $500 in a second to have back those things that are really irreplaceable and don't have anything to do with the monetary value. And it's supposed to be a victim impact statement. It tells me how this has impacted you, but it also has an impact on me because you can read stuff in reports all day long, but until you have somebody come forward and express, as well as you did, the actual effect on your life, and not just your life, but really generations of your family who are no longer going to have these items that they otherwise would have had. I'm not trying to upset you more. I'm just trying to express to you that I think it's important that you came and made that statement today. I'm sure it wasn't easy for you to do. To come here as a victim of a crime and stand in a public place and talk about what you talked about. And I think it's important that you did that, and I appreciate it. I think it sets a good example for other victims to show that it's important for them to come forward. So certainly, I understand how this impacted you. I appreciate the fact that you made it here in court today because it has an impact on me as well. Looking at this as a whole, and it's clear from your background, Mr. Warner, and you certainly do have substance abuse problem, got multiple convictions for that type of crime in the past. You've been, you know, to one degree or another successful on probation in the past, and I hope that you do continue to work on that so that you don't continue along this path that you've been on. Hopefully you can interrupt this cycle that you've been in and stop engaging in that behavior that leads you to commit crimes against people that you might not otherwise have committed if you weren't under the influence of substances. But despite the progress that you've made, it doesn't do anything to make this any better. And there's a price to be paid for your conduct in this case. Part of sentencing is the goal of rehabilitation. In other words, what can we do to help you get better so that you don't do this again? But part of sentencing is also punishment. So that you understand that there are consequences to your actions, and that if you are going to voluntarily use substances, that what you do while you're under the influence affects other people, and you're responsible for that, and you're accountable for it. And so in my view, there needs to be jail time here, given your past record, given the significant impact that this has on the victim, given the fact that it wasn't just money or prescription medications that you took, but you took items that were priceless to these people. And I think that calls for punishment in this case. And so the guidelines in this case are 0 to 9 months. I think the 9-month sentence is appropriate given the impact of your actions in this case. And I think more than absolutely justified in asking the court for that, and I believe that it's justified by the facts in this case.
Sure, I have a 4-month-old baby that I'm the sole provider for my house. Yeah, that's gonna totally. My fiance don't work, is not working at the moment. We have an 11-year-old daughter and a 4-month-old daughter.
Yeah.
I apologize. I didn't even take them items that was the ring or anything like that. I took the pills out of the pole barn or out of the garage in a tow. That's all I took. And I even offered her to give her back to her. So I don't know. I'm sorry. I just am. I know I messed up. I know I did it. Is there any way like I can get like a delay? I'm like,
you've had delays in the past. You've had chances to avoid jail in the past. This is the consequence of what you did. And it's unfortunate that you have children and a mother of those children that are going to suffer because of your actions, but you put them in this position with your own actions. So that's your fault. You're going to have to deal with it. I think a 9-month sentence is appropriate. So the court is going to sentence you to 9 months in the Kalkaska County Jail. You do have credit for 2 days served. Court is going to order restitution in the amount of $500. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. Mr. Travis, if you can have Mr. Warner acknowledge receipt of his appellate rights. Mr. Warner, these pages are going to explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with an appeal. Are remaining to the custody of the county at this time. Mr. Manard present?
he is, Your Honor. Could I have just a minute with him?
We'll take a short recess. A couple minutes ahead of schedule. For the record, People versus Ross is not going forward today. The AG's office informed the court we weren't able to rid Mr. Ross, so we're gonna reschedule this for a later date.
Okay, when I spoke to Ms. Wagner last, I think she thought that she had set it up that they were gonna come. She hadn't had any communication with the AG's office. I think she might have.
Ms. Wagner, I don't know if you have anything to add to that. That's what I got from the AG's office this morning.
I had reached out to that jail and emailed them again, the instructions, the Zoom instructions, the court information for today. And I was under the impression that they were going to have him appear. And like Travis said, I mean, I've not had any contact with the AG's office, but I have directly with the sheriff's department. So I'm not for sure what the issue continues to be.
The only thing I can say is nobody tried to sign in at 10:15 and we're now 15 minutes past the time. So I certainly appreciate you trying to make contact and set that up, but there must have been something along the way that interrupted that.
Okay, I'll try to maybe call him again because I think he's still incarcerated.
Okay. All right. So we'll take a short recess and we'll come back. Mr. Travis, just let the court officer know when you're ready for the time. Okay, we're on the record in People versus Kevin Manard, file number 255065. The record should reflect Mr. Manard is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Menard.
Mr. Manard, did you have an opportunity to go through the pre-sentence report and talk to Mr. Travis
I
about
did.
that? Okay. Mr. Travis, are there any additions, deletions, or corrections that need to be made to that report?
Not that I'm aware of, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I would largely support the recommendations contained in the report. I would just note for the record, we've had some difficulty getting a hold of Ms. Gerald and by extension her daughter, the victim in this case. The plea offer was made after some discussions with Mr. Travis regarding some potential credibility issues with the witness. So I think the resolution in this case is reasonable and appropriate. I would ask the court to adopt those recommendations.
Thank you, Mr. Travis.
Your Honor, I would share that and ask the court to adopt the recommendations in the report. Thank you.
Thank you. Mr. Menard, was there anything you wanted to say today?
No, sir. I would like to be able to go back home and get that portion of the bond lifted so I can start cleaning my home up and get back on track after this ordeal.
All right, I read through the report. I'm familiar with the circumstances that bring you before the court in this case, as well as just the basic information about your background and so forth that's contained within that report. I'm satisfied based on the information that I reviewed, as well as the time that you've already served, that you know, I don't think any additional jail time is appropriate or necessary. I think 62 days, which is what you have served, is a sufficient punishment. Hopefully to drive home for you that this kind of contact is not appropriate, and that hopefully you won't engage in this type of behavior again. So the court is not going to impose any additional jail time, but rather just the mandated fines and costs in this case. The court is going to sentence you to 62 days in the Kalkaska County Jail. You do have credit for 62 days served. The court will order a crime victims assessment of $75, court costs of $325, attorney fees of $350, and $55 state costs. And after you leave court today, you just need to go next door. Did you post money bond in this case?
There was a $750 bond posted.
Okay, so if you go next door to the clerk's office, they can address that for you. And yeah. And you do have the ability to seek an appeal of this sentence because it is a misdemeanor. You would need to file for your appeal within the next 21 days. If you have additional questions about that, you could do that. You could talk to Mr. Travis. He'd be able to answer any of those kind of questions for you. Mr. Ziegler, is there anything else that we need to address here on the record today?
No, Your Honor.
Mr. Travis.
Nothing further, Your Honor. Thank you.
That's all for today, Mr. Menard. Good luck to you going forward. Our next hearing is set for 11:15. We'll be discussing. All right, Ms. Berg, are you there?
Yes, I am.
Okay, and let's see, Mr. Berg, can you unmute yourself, please?
Yes, sir.
There we go. Mr. Berg, are you able to hear me okay?
Yes, I can hear you fine.
Okay, so we're on the record in Berg versus Berg. This is file number 21-13761. Both parties are present by Zoom video. And so we're on the record today. Ms. Berg, you filed a motion with the court regarding the sale of some real property. Is that correct?
Correct.
All right, and your motion indicates that Mr. Berg is not participating in the sale of that property, is that right?
Yes, he wants to keep the property. And when the real estate agent came there, the dog bit one of the people, and then I had another real estate agent, and she won't work with him because he got rude with her on the phone. And I was trying to communicate with him about it, and he changed his phone number 3 times. And he just doesn't want to agree on a price. And since I got remarried, he started sending me nasty messages again, and he wants to change all the rules.
All right, so you're not staying at that property anymore?
No.
Okay. All right, Mr. Berg, what's your side of this?
I disagree with her. I have a letter of cooperation from the realtor.
Which one?
Franco.
No, we canceled him.
No, the listing just stopped.
Yeah. He tried it for another 3 months because of the dog incident and stuff.
We've had the home on the market for over a year and a half already.
You're making it to where the real estate agents don't want to deal with you. I got another one from Manton. Her name was Tammy. I can't remember her last name, to call you, and you were rude to her on the phone. And she goes, I'm not dealing with him.
I was never contacted with a Tammy.
Yes, you were.
No, I was not.
I also gave you her number.
All right, well, it's not going to do any good for the two of you to argue back and forth here. The only way I can really resolve this, I mean, Ms. Berg, you're saying he's not cooperating and he's causing problems with realtors. Mr. Berg is telling me that he is cooperating. So the only way that I can resolve it is to have a hearing where you both come into court. Ms. Berg, if you have realtors that can testify that Mr. Berg, hasn't been cooperating, or that he's been, purposely holding up the sale of property, you'll have to call them as witnesses. Mr. Berg, same thing. If you have a realtor who can testify that you have been cooperating, then you'll have to call him as a witness. But the only way that I can resolve this as the judge in this case is to decide, because you're both telling opposite stories and they both can't be true. So I have to take testimony and decide which one is more believable, and then make my decision based on that about how we're going to get this to move forward. So that's the only way that I can resolve it, unless the two of you can communicate outside of court and come to some type of agreement. So Ms. Berg, is that how you want to proceed?
I will be willing to cooperate with Brian if he will cooperate with me and stop saying things to me on the phone the way he does. It's ever since I got remarried, he started this stuff up again, like before.
All right, Mr. Berg, I mean, can you work with Miss Berg to get this taken care of?
Yes, sir, I think I can.
Okay,
All
no
right.
calling names anymore. Like calling my husband names and.
That's fine, Dawn.
All right, so I'm gonna set this for a status conference in 30 days. I'm gonna ask the two of you to try and communicate here reasonably with each other to get this resolved over that period of time. Ms. Berg, this is your motion, so you know, it's gonna be up to you to tell the court whether you've been able to resolve this or not. And if you have, then let us know before that hearing, and neither of you will have to appear. If it hasn't been resolved in 30 days, then I'm gonna set it for an evidentiary hearing where you both will have to come in and testify, and I'll make a decision and you know, move things along one way or the other. Okay, Ms. Berg, do you understand how we'll go forward?
Yes.
Do you have any questions for me?
So if he and I can't resolve things within 30 days, then we'd have the hearing. But if we can, I still have to let the court know.
Yeah, that way we can take it off the docket so that you don't have to take up your time. Mr. Berg doesn't have to appear, and then I can put something else in that, use that time for a different case.
Okay.
Mr. Berg, do you have any questions?
No, sir, I do not.
Okay. All right, thank you then. That's all for today, and you're both free to disconnect at this time.
Okay, thank you.
Thank you.
That concludes our court's morning docket. We'll be in recess.